He runs a practice law firm with a strong bias for intellectual property, anti-counterfeiting, anti-piracy, brand protection, and IP valuation, as well as criminal law practice and advocacy. He has organized and served as a resource person at seminars and workshops for law enforcement agencies and stakeholders in the creative community in and outside Nigeria, aimed at creating awareness of the menace of counterfeiting, piracy, and organized crime, and endangering respect for intellectual property and human rights. He has designed and implemented anti-counterfeiting, anti-piracy, and brand protection schemes for clients aimed at the sole purpose of brand/IP protection. He has engaged in voluntary activities with the objective of contributing to Nigeria's socio-economic and technological development through the promotion of and participation in activities of civil society groups aimed at alleviating poverty and enforcing and advocating for fundamental rights. He currently serves on the board of organizations. From July 2011 to date, he served as he's the principal counsel at AO Apomade and Co. Lagos. He coordinates the activities of a team of lawyers in litigation, corporate practice, and civil society advocacy. He develops appropriate anti-counterfeiting, anti-piracy, and brand protection training programs for law enforcement agencies and stakeholders. He supervises the firm's investigative activities aimed at obtaining and securing crucial evidence of infringement of intellectual property rights. He represents clients at the Alternative Dispute Resolution Forum. I want us to start giving our virtual applauses. And he designs and implements anti-counterfeiting, anti-piracy, and brand protection schemes or IP security devices for clients. To mention but a few, he has made several publications, some of which include the role of the Nigerian lawyer in the fight against product counterfeiting. And notable achievements can be seen as his coordination of anti-piracy raids against the three clandestine pirate CD plants in Lagos 2004, among several other remarkable achievements. With a virtual applause, please let's welcome our speaker, Barrister Akim Apomade. Welcome, sir. We're very happy to have you here, sir.
Thank you very much for the introduction. My name is Akim O. Apomade. Apomade. I believe it's important that we get proper pronunciations of names, especially African names. When a Chinese mentions his name, we try to get it right. If it's someone from Eastern Europe, Russia or Poland, and say Mr. Lewandowski, we try to get it right. So we Africans should also learn how to get our names right when we pronounce them. It's important. Again, my name is Apomade. Now, I want to thank my dear lady, Mrs. Oni, for deeming it fit to invite me again to be part of this. If she did not, and I'm aware that this will be taking place, I'm likely to invite myself because I see myself as a co-partner with her in this journey that she has undertaken. This is one of the things that are all supposed to be doing, giving back to the society. And the mentorship that she's giving you, it is not only for you to understand the issues surrounding intellectual property rights alone, but to learn how to give back to the society. And I want to commend her for the sacrifice that she has been making, for the effort she has been putting into this, and for sustaining this program over the years. Um, the walls of teachers, they say they are in heaven, but I believe that God has changed that. That even teachers are getting their rewards here on earth, and I believe that you will get yours too. So thank you so much. Um, I will crave your indulgence to allow me to start. I bet to expect that at a point I will have to take a pause in order to alight from my car. I just arrived from a trip, so I am in the car right now. So I will start uh, uh, this lecture at this moment, and then when I get to the office, I will have to move from the car into my office. So at that time, I will let you know so that I can take an interlude to get inside the office and continue. So thank you so much. I believe that I have you hearing me and listening to this. Hello?
Very well, sir. Hello, sir.
Okay.
We can hear you.
Okay.
Thank you so much. Good morning, sir.
Good morning to you. Good morning
And
to
we're
you.
sorry for the stress. I know you're still on the way. Thank you so much for this.
No.
Thank
It is
you.
with pleasure, that I'm doing this. It's pleasure. Thank you so much.
Very
Now, I I told my dear lady that I would like to speak on matters that are practical, because what you are learning through this series is not supposed to prepare you for an exam, but rather to prepare you for how you make a living. So I decided to speak to you on issues that you may come across in life. Yes, some of you may be students today, but by having an understanding of what happens in real life, you will be able to marry it with whatever that you are taught in school, so that this thing leaves the level of being esoteric to something that is practical. So I titled it for as practical issues in IPR practice and get say or understanding intellectual property rights practice. Now, in understanding the concept of IPR, I would like first that my audience imagine or believe that there's a supreme being somewhere. Um, that supreme being we call him God, and in different languages to express who God is. But that God, see him as someone who is benevolent enough to give unto individuals different kinds of gifts. The intellectual capacity to create something. Now, that which is created may be physical, it may be tangible, it may be intangible, but it arose first from the mind. It arose first from from someone's intellect. Take, for instance, someone is able to bring out a medical formula for curing mpox. We must be hearing or seeing pictures of those who are afflicted with mpox. Or it's Ebola, or it's COVID. Now, imagine that someone is able to come up with something, with a solution to a problem. It may be just writing a book or writing a story. It may be writing a film script. And someone may just look at, say, okay, I want to sell soda. Okay, American people call it soda. In Nigeria, we call it soft drinks. Say, okay, I will design a symbol or a mark that will be used to identify these goods, that these goods are mine. They are not, my own soda is not Coca-Cola. My own soda is not Pepsi-Cola. Mine is different. When they look at it, they know that this is mine. And such a symbol or mark is made. Now, the society decided that such creations, they deserve to be recognized as property. Such creations deserve to be protected as property. And so the society enacted laws. And it's those laws that will say this qualifies, when you meet these social requirements, it qualifies as copyright. When you meet social requirements, it qualifies as trademark. When you meet social requirements, it qualifies as industrial design. And etc. And by meeting those requirements and having qualified as social property that we have mentioned, whether it's trademark, geographic indication, or whatever, that for this number of years, you must enjoy exclusive ownership. The way you will enjoy exclusive ownership over your car, your shirt, or whatever property that you have, or your house. But being intellectual property, the law sets a limit to the number of years that you can enjoy this exclusive ownership, whereby you can say no one should touch the work. So I think in a practical sense, that is what intellectual property rights is all about. Now, when you look at the principle of ubi jus ibi remedium, which the Supreme Court explained in the case of Oyekomi and NEPA, 2000 Law Pavilion Electoral Law Report 2873, that where there is a right, there must be a remedy. Where there's a right, there must be a remedy. So, if the law recognizes that by creating a mark and registering that mark to distinguish your goods from the goods of others, you are the proprietor of a trademark, and that trademark must be protected. If anybody touches it now, if anybody makes a mark that resembles yours and places upon a product with the intention of passing off his goods as yours, then that person has infringed on your right created by law. And by law, relying on this principle of ubi jus ibi remedium, to have a right of action to go to court and challenge what the person has done. Take copyright, for instance. The Copyright Act recognizes 6 distinct works: literary works, artistic works, musical works, audiovisual works. Before the amendment to the Copyright Act, it used to be called cinematograph works, cinematograph films. Then you have broadcast, and you also have sound recording. There are 6 distinct works. Now, the rights that we are talking about, which that's why people will tell you that intellectual property rights are statutory rights. They are rights created by law. So the law will set the boundaries, the limits. Number one, what qualifies to be a work that is protected by copyright, that copyright vests in it? It is a law that will set the boundaries, give the criteria. So whatever is not, does not fall within the parameters that the law has set will not be qualified as copyright. The same thing as trademark, same thing as industrial designs and others. Then the law will also state how you can enjoy the rights, the extent to which you can enjoy the rights. Talking about the duration, the period within which you can enjoy this right. Then it will also mention the issue, like as I mentioned, the issue of copyright, that you can license your work and you can assign it. Assignment of intellectual property rights is the sale of such rights to someone else, just like you are selling a piece of land. And when you sell it, when you assign it, means that you have divested yourself of your copyright, of your interest in that particular intellectual property right. And in the developed world, IP portfolio of an organization or an individual is valued. You can say Coca-Cola trademark, the trademark Coca-Cola, not Coca-Cola's factory I'm referring to now, but the trademark of Coca-Cola, that this is what it's worth. And Coca-Cola can take that to the bank and use it as a collateral to obtain a loan. Coca-Cola can sell its trademark and assign its trademark. And when it says it means I cannot use it anymore, it will still have its factory. Perhaps it wants to start all over again. But this tells us how valuable IP is as an asset. Now, I was talking about copyright licensing. Ladies, please permit me to pause here. I've just arrived in my office, so I'll continue as soon as I go inside. So thank you so much.
Ladies, let's kindly hold on. He took permission to step into the office. He just returned from a trip. And so he was in the car when he was presenting earlier. He just got to the office and would want to step into his office, settle down, and then he will return. In the next few minutes, we should have him back on the session. So let's be patient for some minutes. God bless you all.
Yes, I am back.
Welcome
Can
back,
you
sir. Yeah.
thank you very much. So I believe everybody can hear me now.
Yes, sir.
Okay, very good. Now, I was saying that you can license your work, and a license may be exclusive and may be non-exclusive. Well, referring to copyright now. And the license may be for a specific period of time and may be limited in terms of jurisdiction. You can say, I license you to make a film out of my script, which you can only sell in Nigeria. So leaving you with the right to license someone else to make a film out of the script outside Nigeria. I can say, I license you to do this film for 30 years or for 20 years. I can say, okay, and within that period, you are the only person that I will license to so do. Or you say, okay, it is not exclusive. It is not exclusive. I can license as many people as possible. And you realize that all this is about this. If you can see my hand, what does that mean? Money. Money. Your right at the end of the day translates to the power that you have to grant someone approval to do what you alone can do. And since corporate owners are not they are not created to be charitable every day of their lives, it means that they don't grant the approval free of charge, and that is where the wealth comes from. I have said it a countless number of times that the richest woman in England is a copyright owner. All what she has been doing is to write the Harry Potter series. And that is where she's making her money from. So, intellectual property rights translates to wealth. Now, take the Trademark Act or patents under the Patents Act, the Industrial Design Act, that is the Patents and Industrial Design Act. When it comes to infringement, they did not provide expressly for criminal enforcement. The rights that are derived from these statutes, the Trademark Act and the Patents and Industrial Design Act, they are civil rights. That if anyone infringes on these rights, the owners have a right of action to go to court for the enforcement of their rights. Now, when it now comes to criminal enforcement, the distinction between copyright and industrial property rights is that The Copyright Act itself provides expressly for both civil and criminal enforcement, while the laws that recognize industrial property rights. Industrial property rights are those rights like trademark, industrial designs, geographical indications, patents. Those are industrial property rights grouped together. There is no, these laws do not provide in any of them. You don't see anywhere it says that anybody who does this shall be liable to pay a fine or go to jail for a number of years. No, but the Copyright Act provides for that. So if you read the case of Digital Communication Network Limited and the Nigeria Copyright Commission, it's in 2013 LPLR 2797. It's a Court of Appeal decision. You understand what I'm talking about. Now, but that does not mean that, and so I want you to take note of what I'm telling you, my dear ladies. When you have a client come to you as is complaining about infringement of his or our trademarks or patents, does it mean then that there is nothing that you can do? There's no advice you can give. I said, look, I don't want to go to court. It takes a long time before decisions are made regarding civil matters. All I want is to get law enforcement agencies involved. And you must know as a lawyer that law enforcement agencies are not expected by law to get involved in civil matters. If the rights that are created by a particular conduct, the right of action, is civil, you cannot bring law enforcement agencies in. They can only act when the matter is a crime, when the matter is an offense. And by virtue of Section 36, Section 12 of the Constitution of the Federal Republic of Nigeria, no one can be punished for an offense, for a matter that is not so declared to be an offense in a written law, and the punishment prescribed therein. So, take for instance the question of adultery. For those of you who are students, this is legal method now. Adultery in the southwest, the southern part of Nigeria, or the southern states of Nigeria, is not an offense. It is a reprehensible conduct. It is immoral. But there is you cannot find any statute where it is the offense of adultery is defined. When a man goes to sleep with another man's wife, or a married man rather goes to sleep with another man's wife, or a woman that is not married, or it is a married woman that does that, it is a breach of the trust and the contract between the husband and the wife. But the question is there any law where that is written that anybody who does that commits an offense and that the punishment is also a number of years or just a fine? If it is not so stated, then it's not an offense. You cannot go to the police station and say, I want to report that my husband is sleeping with somebody. That does not make it an offense. So the same thing, that if you follow what I've said so far, that the Trademark Act, the Patents and Industrial Designs Act do not expressly provide for criminal sanctions. They did not define infringement of trademark to be an offense, or infringement of a patent or industrial design to be an offense. Does that mean? So because I've said that, don't go about saying, oh, I can't report to the police. So if your client comes over to you and reports cases of infringement of his or her rights, and he says, I don't want you to file a suit. No, it's not see what I want. I want the police to get involved. Or any law enforcement agency. Will you just fold your hands and say, oh, there's nothing I can do? Mr. Kumade has said that Trademark Act and Patents and the other Act do not provide for criminal sanctions. Now, let me tell you, even though that is the case, there is a cocktail of legislation, a number of laws which were made for us to arrive at the same enforcement destination. Like, for instance, the Merchandise Marks Act. Go and read it. Paragraph section 3. It provides for criminal sanctions for infringement of trademarks. So even though you cannot find it in the Trademark Act itself, but by going to the Merchandise Marks Act, you'll find it there. The Standard Organization of Nigeria Act, you'll find provisions that you can use to enforce criminal sanctions against infringers. You also have the Counterfeit, Fake Drugs and Unwholesome Processed Food Miscellaneous Provisions Act. NAFDAC uses this when they come across people who use who counterfeit products that are under their purview. Now, I'm sorry. Now, with the establishment of the Nigerian Corporate Commission, and the powers that the law, the Corporate Act, donated to the Commission's corporate inspectors, and the general powers of the police to investigate crimes in the country, it is much easier to enforce copyright by means of deployment of state machineries and by virtue of the elaborate provisions that the Corporate Act has on criminal liability. Now, going back again to the issue of ubi jus ibi remedium, IPR generally, they are enforceable through civil processes. You file, somebody comes over to you that his right has been infringed, you get the facts, you get the evidence, and getting evidence of infringement is very, very key. And as far back as 2006, when I had the privilege of presenting a paper at the annual general conference in a program organized by the Young Lawyers Forum, I had advocated and suggested to the bar leadership that lawyers should be encouraged, particularly in the field of IPR practice, to add investigation to their portfolio, because you can hardly have a successful IPR practice if you don't have a firm of investigators working with you, or you have investigators in your own firm working for you. Because if we are talking about infringement, you must have evidence of infringement, of the infringement. So how do you gather the evidence? If you don't have the evidence, then you cannot succeed. Because in most cases, even though you can find a few products in the market, if you really want to fight IPR infringement, you need to know where this is and where the whole lot is kept. You need to know how they come into the country, who is importing. If not, you just find a few pieces and then you go to court on the basis of that. While you are in court for 5, 6, 8 years, the man is continuing with his act of infringement massively. And I have an experience of that. That at the Federal High Court, as of today, I have 2 cases against the same person. The first one was filed in 2017. Judgment will be delivered, God willing, on the 11th of October. But the man did not desist from further acts of infringement while this matter was going on. And so early last year, our clients came over again and said, look, we bought a copy of this in the market. So you need to find out what is going on. And by the time we came back, we realized that it is this same person who has been infringing on these things. And in fact, he has even gone to court, gone to the trademark office to seek to register his own version of the trademark. And when we got to know about that, we now had to file an opposition to it. So you need to understand that in order to file a suit for your client, you must have evidence of infringement. This is what the court will rely on in coming to a decision. Now, when you are talking about civil enforcement of IPR, you must know that there are 2 main areas of law that you may be inviting the court to intervene in civil enforcement of intellectual property rights. 2 broad areas of law. One is the law of torts, and the other is the law of contract. In torts simpliciter, the courts are often invited by the plaintiff to determine whether the defendant has infringed the plaintiff's IPR. You are asking the court to determine whether the IPR, as recognized by the law, has been infringed by the defendant. And you are praying the courts for remedies, which will include injunctions, accounts, damages, etc. While in contrast, there may or may not be an infringement of the rights. But your course of action, there may not be an infringement of either the trademark we are talking about, or whether it's copyright. It's not about infringement of the rights, but rather you are asking the court to determine whether there's been a breach of the contract between the plaintiff and the defendant. And I would like you to please understand the decision that I'm trying to make here. Take sound recording and musical works, for instance. That is all literary work, where an author takes his manuscript to a publisher. The author is the owner of the copyright in the book. For the publisher to publish the book, the publisher and the author must sign a contract. It is required. It is important that they sign a contract. When they sign the contract will spell out the obligations of each party. We will publish this book and sell it at a price that we will agree on. And for every book that is sold, you'll be entitled as the author to 20% of that amount. Or no, we will sell the book at the price that we agree on, and then we will deduct for each book. We know the cost. We will deduct the cost from the price. So whatever remains, you'll be entitled to 10%, 20%, 30%, or any percentage. This is what you'll be entitled to. That will be written in the contract. Now, the two scenarios I've given you, that thoughts, infringement of the copyright, contract, a breach of the contractual terms of the agreement. Now, if the book is now being pirated, is being reproduced by someone else other than the publisher, the author has a right, along with the publisher, to go after that person. So when you go take such a person to court, it is the issue of tort, it is copyright infringement that you're talking about. If now this author, the publisher, is not paying the author for the books that he has sold, that is not an infringement. That is a breach of the contractual relationship between them. And it's possible that the publisher and the author might, in the agreement, the author will have vested in the publisher the right to relate with others on the work. So let us assume that now the publisher licenses someone else, say in England, to publish the book and sell. And the agreement will also state the obligations of the licensee in England. If the licensee himself is now not fulfilling his obligations, and you want to take the licensee to court, the issue is about contract. It's not about infringement of copyright. So I hope you understood the decision that I've tried to make there. Can I? Yes, I'm seeing Lola's hand up. Will you wait until I finish so that I take all the questions together? But for now, I just want to have a response from as many as possible. Are you following my drift? Okay. Oyichi, yes, I got you. Say yes, sir. Yeah, Favor, yes. Jennifer, yes. Hope, yes. Thank you. Yeah. Umesoma, yes. Thank you. Thank you so much. Thank you so much. Okay, so I will continue. Now, when it comes to contract, those of you that are offering international law as a course, you will get to understand this principle I want to mention now. But it's a principle that governs every contract. It's an elementary principle of contract. It's called pacta sunt servanda. Pacta sunt servanda. You know, pacta sunt servanda is that you must stand by what you have already agreed that you are going to do. You must stand by your word. Now, in the case of Benocam International Resources and Honorable Commissioner, Ministry of Works and Transport, Akwa Ibom State, which is a 2019 Law Pavilion Electronic Law Report, number 48523, is also a court of appeal decision, captures this principle So if you have agreed that you are going to pay an artist a particular sum of money, you must pay. You must follow it through. And if you're an artist, you have said that I will release 3 works for you before I move on. Or if I want to renew it, I renew. If I don't want to renew it, I move on. You must not leave the record label before the expiration of that period of exclusivity. That is what it's all. That's what it's all about. When you breach that, then the other party has a right to go to court and enforce his right. So, what I'm trying to put across to us all is that any action that is arising from an IPR contract, because you take it, I mean, understand this. When an artist, when an author aligns with a publisher through a contract, that's how they do it. Now, arising out of that contract is the production of a book. That book, there is copyright in it. So if anybody now infringes that book, then you will see a copyright action that is coming out of it. So this is the basis upon which an IPR holder, goes to court. Is either he is enforcing his right in the IPR or is enforcing his right in the contract. Now, take for instance any dispute between 2 parties to a franchising agreement. On the right of the franchisee to use the franchisor's trademark. It is arising from the terms of the contract between the parties. And this has no issue with whether the trademark itself is infringed or not. You see many, the company that first understood the principle of franchise in Nigeria, I mean, that's my understanding. Anyway, I may be wrong. It's Mr. Biggs. Now, UAC decided to create Mr. Biggs, and we're now licensing people after paying them their franchise fee and giving them conditions that they must meet. So anybody anywhere can then open a Mr. Biggs eatery, put Mr. Biggs sign there. Such a person is the franchisee, and UAC was the franchisor, the owner of the Mr. Biggs trademark. Now, if take for instance, Mr. A decides to take on the franchise, and Mr. A did not follow the conditions set, then UAC had the right to go to court to enforce his rights. But it is not because Mr. A is infringing on the trademark of UAC, but rather it is because Mr. A has breached the terms of the franchising agreement between them. Now, the law makes it easier to adjudicate on contractual matters in the copyright field. Section 33 and paragraph A of the Copyright Act, for instance, provides that no assignment of copyright and no exclusive license to do an act, the doing of which is controlled by copyright, shall have effect unless it is in writing. So the question now is, what is the first step? if you want to have an exclusive license, or you want to have an assignment, it must be in writing. So if somebody comes over to you and saying that, oh, I assign my right to him, or I assign his right to me, and then there's this, there's that, or I'm the exclusive license of this thing, you will ask the person, where is the document that you are referring to? Yes, it has been said that the court will not allow somebody who has benefited from an unwritten agreement to reside therefrom only on that ground. The question, so I mean, there are decisions of court, relating to that. If as far back as 1973, there's a Lababedi and Lagos Metal Industrial Nigeria Limited. But the question is, if somebody is claiming that a copyright or a trademark was assigned to him, he asked the owners to produce that document, because it is a policy document that will be able to show you the terms. So without him showing you the terms and no document to show the terms, how would the court be on his side? How would the court agree with him that what he's saying is true? So, and it places the onus on the person that is claiming that there's an assignment to produce a document that will evidence that assignment. Without it, it will be difficult. Now, when a contract is reduced into writing, what it does is that it engenders certainty in interactions among the parties. So because nobody knows what will happen in the future. But when you are entering into an agreement today, and this is what the advice you should give to your clients when they come to you, that they want to assign their rights, or they want to someone to assign these rights to them, this thing must be in writing, because disputes may arise in future. And when these disputes are taken before a court of law, the court will only interpret the terms of the agreement so as to give effect to these terms without importing anything into the agreement. So if it's not written, what is the court going to give effect to? Now, between an artist and a record company, for instance, there's always what we call the exclusivity clause, which will state the period within which the artist is precluded from entering into any copyright assignment or license contract with another person. This becomes necessary because of musicians' proclivity to release as many songs as possible. Some musicians are so gifted that they can release songs on a monthly basis. Now, if one of you is a record label, you invest in releasing my work, and I'm so gifted that I can write 100 songs in a month. Now you release my first album, you will be the one to invest in publicity, in the production, in the sleeve. Sometimes you will give me money to buy my wares in order to leave it up out there. Now, if you do not have a contract that binds me to you, that prevents me from releasing another record, I will release another one. It may be for another company. I may even say I'm doing it on my own. That is going to affect the returns on your own investment, because the moment I bring out a new one, people will abandon the old one and they go for the new one. That is the essence of the exclusivity clause in an artist agreement. So if you are preparing one for your clients, if you don't put it there, your client may lose out at the end of the day. So exclusive clause is very, very important. Now, so it seeks to protect the record company or record producer, as the case may be. It's the same name, especially under international conventions, the Rome Convention and the WIPO Phonogram Producers Treaty. Now, so it is in recognition of the dirty practice in the industry, because it's a dirty practice. I've been involved in the music industry for over 30 years now. So when the industry was before the advent of digital economy, it was a cat and mouse race in industry. Dog is dog. If I know that your artist is selling well, I will woo your artist with money and ask him to come over to me. So, and that was why this exclusivity clause was inserted in every contract. When you do it as an artist, you know that you'll be taken to court and you pay heavily for it. And all what you have sold or your new record company has sold, there'll be an order for account, and you will give the money to your first record company, because the period of release that they will release you has not yet come. So now, so as I said, if you don't bring that in, you will not be able to secure an artist's fidelity for him to release as many records or albums as you have agreed that he must do for you before he goes somewhere else. But I have discovered that in practice, amongst lawyers, as well as even on the bench, this exclusivity period is easily misconstrued for the duration that the record company will own the copyright in the music. It is not so. Before 1988, the duration of copyright was 25 years. After the Copyright Act was made in 1988, for each specific work, I mentioned the 6 of them at the beginning of this lecture. Each of them, the law gives a duration. So it is not a blanket one. But the list is 50 years after the end of the year when the work was made. And that is for sound recording as well as for broadcast and cinematograph, audiovisual works. For literary works, musical works, and artistic works, it is 70 years after the end of the year in which the author died. So throughout the lifetime of the author, he will continue to enjoy, he will continue to enjoy copyright. Then, if he dies in December or January of 2024, then from the 1st of January 2025, we begin to count 70 years. That one will continue to enjoy copyright until 70 years thereafter. Now, I want to know how many more minutes do I have before you pull the plug?
30, sir.
30. Okay, very good, very good. I'm almost at the end of it all. Thank you so much. Now, I want to make a practical demonstration of things that you can come across in the real world. especially with regards to the music industry. The Copyright Act recognizes musical works as well as sound recordings. And I'm sure that some people will have wondered, what is the distinction between the two? Simply put, musical works are the lyrics, the music that is composed by somebody. So when you compose a piece of music, that is musical work. What happens is that in the Western world, where the concept of intellectual property rights, copyright and the rest, were brought from, music is first written before it is performed. It is first written. In our own part of the world, majority of our musicians don't write their songs. They bring them from their brain, they sing it again and again. Before they had any beats to it. And these days now that you can record what you are singing, what you are creating in on a cassette or CD or even your phone, and listen to it before you now look for drummers and trumpeters and the rest, guitarists to come and play. That is what you have. But we always make a distinction this way, that you cannot dance to a musical work. Now, a sound recording, on the other hand, is when you bring the musical work, you bring the guitarist, you bring the keyboardist, you bring the drummers, and then they perform everything together, and it becomes a sound that you can dance to. That is a sound recording. Now, the Copyright Act provides that in Section 38 that the owner, the first owner of copyright in a work is the author of that work. The first copyright owner is the author of that work. I want you to understand this carefully. Now, who is the author then? That will take you to the interpretation section, which is section 108, where the law now defines the author of each work separately. And it says that with regards to musical works, the author is the creator. So in that case, the artist is the creator of his musical work. We have also gotten to the stage in Nigeria where the author of a musical work is not necessarily the person who performs it. Because there are some people that are gifted in creating music, but they are not gifted with a good voice. So, an author, a creator who is a composer, will write the song and somebody else will perform it. The person who performs it is not the author, is not the copyright owner. He's not the first copyright owner. The only way in which he can become a subsequent owner of the copyright is if the author sells him his right in that music that he has created. That is when, take Davido for instance. If Davido did not write the songs that he has been performing, and there is no agreement between him and the person who wrote the songs for him, that person has divested of his interest in the songs and given the song to him, Davido cannot be the owner of the copyright. Now, with regards to sound recordings, There's a difference. The difference is that the author of a sound recording is defined as the person who made the arrangement for its making. The person who made the arrangement for its making. It's the same definition for broadcast, the same definition for audiovisual work. And here we are talking about the company. And if it's an individual that stands in the place of a company that says, I will take you to the studio. Do you have a band? Okay, you have a band. Bring your band members. I will employ a technical producer who will put this thing together in the studio and produce a master tape out of your work. If it's a record company, in most cases, a record company will even have its own studios. Come over. We have our in-house producer. And then the person now tells the musician, oh yeah, and his band boys. And he doesn't have band boys. It is this person in furtherance of his duty to make arrangements for the making of the sound recording. He will get everybody that will perform one way or the other together to back this person up. And then he now performs his musical work. And then all these people add percussion and everything. And then the work is produced in a master tape. So the person who was responsible for the making arrangements for the making of the works is that company. And that is the author of the, and that is the first corporate owner when it comes to a sound recording. And that is the distinction between a sound recording and a musical work. And we talk about first ownership of copyright because the law allows the first owner to sell off his rights. The person who buys from me can also sell it to somebody else. I can go on and on and on and on and on and on. And it may also be disposed by way of testamentary disposition. So that the person who owns it now may be the child or grandchild or great-great-grandchild of the first owner. So, but when you are talking about who was the first owner of this work, they will say it is the author. And also for the purpose of acknowledging that person as part of the author's moral right, you need to distinguish between who is the first owner and who is the secondary owner or subsequent owner of a work. Now, this area has been causing a lot of confusion, and there's a particular disturbing decision of the Federal High Court, which was affirmed by the Supreme Court. Sunday Adegeye against TYC. And this particular decision, which has to do with King Sunny Ade and his former record company, was reached by Korean because it did not follow the law. We are hopeful that now that the matter is at the Supreme Court, the Supreme Court will be able to set the record straight. It makes the hearts of those who are knowledgeable about IPR to bleed because it's travesty of justice. You know. Now, to know who owns the copyright in any work, so it is the copyright law that we go to first. Since the copyright law contains so many default provisions, we then go next to the copyright assignment or license agreement for a guide. As I've mentioned to you that the author is the first owner of a work, and that copyright work can be transferred by assignment, you must note that licensing does not transfer ownership. When you license your work, you retain the national interest in that work, whether it is exclusive license or it is non-exclusive license. You must know that you continue to hold the right to the work. And the explanation I gave you regarding sound recording and who owns the copyright in sound recording. Section 108 of the Copyright Act defines the author who is the first owner of copyright in sound recording to be the person through whom the arrangement for his making was made. Now, that in itself is actually an affirmation of what the international law says as contained in the Rome Phonogram Producers Convention, as well as the WIPO Phonogram Producer Treaty provides. They recognize that the record producer, which is the record company, is the owner of the copyright in every sound recording. So if an artist comes over to you and is talking about his right being infringed, after he has signed an agreement with the record company, or he does not have an agreement with the record company, you need to ask to educate that particular artist that as far as the law is concerned today, the record company is the owner of the copyright in the sound recording. If you want to lay claim to the contrary, you must show a contract, a written contract, which spells it out that the record company has given you that right, that copyright, or else it will be a lost battle that you want to fight. I want to give you two scenarios which I want you to think about. And please listen carefully. The first scenario is that an artist, Itu Baba, let me call him For Baba, and Karakuta Records, they executed a copyright assignment agreement on 1st February 1990. The agreement contained an exclusivity clause. For Baba agreed to release one album for Karakuta Records within 2 years. Now the artist assigned all his copyrights in the musical works to Karakuta Records for a consideration referred to as royalty, payable on sale of copies of the sound recordings. Karakuta now has released For Baba's album containing 5 songs in 1991. In 2021, the artist is angry that even though Karakuta Records has continued to reproduce and sell copies of the sound recordings, the last time he was paid any royalty was December 1996. His lawyer has advised him to file an action to claim infringement of his copyright in the music, in the sound recording. His reason is that given the 2-year period in the exclusivity clause, Karakuta Records was to enjoy copyright in Baba's album for only 2 years, and that any exploitation of Baba's works longer than 2 years is an infringement. He is now seeking a second opinion from you. Okay, no, let me say it from you, from another lawyer, who now said the artist had already assigned the copyright in his musical works to Karakuta Republics, and that Karakuta Records has the right to release the records, and that the only thing that this artist is entitled to is royalty, and that if he's not paid, he has the right to bring an action for breach of contract so as to recover the unpaid royalties. So my question is, who is right? Is it the first lawyer who said that the record company that has an agreement with this artist is committing an infringement of the copyright of the artist, or it is second lawyer who said the company is not infringing on your copyright, but the company has breached its agreement with you. It agreed to pay you royalties. Having not paid you, you have a right to recover the unpaid royalties. Which one is right between these two lawyers? On that note, I just saw somebody, fan. You are making me so happy by your responses. Oh, this is wonderful. It means that you are listening. It means you are all listening. Ugu, thanks so much. Yes, everybody is saying this. I'm not mentioning, what each person is saying, but everybody is saying the same thing, and you are right. You are very, 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 very right. You are very, very right. The joy of a teacher is that his students understand what he's saying, what he's teaching, not that he's talking to himself. And you have all shown that you are listening attentively. And on that note, I want to thank you and thank Mrs. Oni once again. Debbie, you are an angel. May God keep you for long for us. Thanks so much.
Thank you, sir.
So I'm ready to take your questions.
Thank you so much for this highly insightful session. Deborah, are you there to lead in the questions to check whether there are? Okay, over to you.
Okay, well, thank you very much, sir, for this very insightful session. It's really made me feel like I was in the classroom with my lecturer. Thank you so much for the insights, sir. So I'm going to delve into the Q&A. And okay, we have one question. Thank you so much, sir, for today. I learned a whole lot on IPR. Please, I didn't get the case you mentioned in the Latin words that means you have to stand by your words.
Thank you so much. It's I said pacta sunt servanda. Did you get that? And yes. The case is Benocam International Resources Limited and Honorable Commissioner, Ministry of Works and Transport, Akwa Ibom.
Duly noted, sir.
And others. It's 2019 LPELR 48523.
Yes, sir. Thank you very much, sir, for that detailed answer. Another question from Jennifer Chinamelu. What are the two areas of law mentioned? Contract and what? Okay, it was answered. Yes. Taught.
Yes.
Taught. Thank you very much, sir. Those are the questions for this session, sir.
Okay. Thank you so much.
Yes, sir.
So am I free to leave? Favor is raising her hand.
Okay, all right. Let's Deborah, please enable Favor to speak.
Okay, ma'am. There are two new questions that dropped in the chat box.
Okay.
Yes, so I would. Okay. For a contract, an agreement that was made orally before you become their practitioner, what do you suggest I do? I'm still trying to.
Yes, I heard you. Now, if there has been a contract and agreement before an oral agreement before you were made a lawyer, you advise your client that what was agreed upon should be still reduced into writing. It's not late. It is not late.
Thank you very much, sir.
Deborah would like to answer the question.
Okay, sir.
Okay. Now the next question.
Okay, sir. And the next question we have, thank you very much, sir, for this beautiful session. Is there a way we can get your slides?
I did not have a slide. I just had, talking points. Um, so unless I subsequently reduce this into slides. Let me confess to you. Hmm? Anytime I have a presentation to make, and because I'm always so busy, there is I have two sons who are lawyers and they are in this field as well. I always give to one of them to let me do the slides. I will just do the work and give to them. Unfortunately, one is very busy, very too busy doing something for himself, and I felt that it would be unfair of me to bother him. The second one, he was actually not in the country, but he has a master's degree in IP law and internet law. He also he has just gotten a job that did not allow him to have time for me. So I was not able to now do the slides myself, and that's why I have to rely on um, the talking points that I had to make this presentation. So I will have to do it by myself and send it subsequently.
No problem, sir. Thank you very much, sir.
All right.
Thank you so much on that. I understand the burden and the sacrifice that our great learned senior here has made to be on this platform. And this is not his first platform. He is one of our pioneer speakers from the very beginning, from 2020 of this platform. And he's been doing his best always in the midst of his busy schedule to be here. So ladies, please, we're going to pardon if we're able to get this slide subsequently. Of course, the schedule is a very tight one. We understand that he was in Abuja when we spoke early this morning, and then when he got to Lagos, still on the way, he started the presentation. So the recordings will be shared. I hope you did take notes. And then from the recording, you're able to also refresh your memory and take out more points, so we don't put so much burden on him this session. Other editions, we've had him also try to squeeze out time to get us slides and documents around the presentation. So I'm sure if you were really attentive in the class, you would have taken a lot of notes, and the recording will also help you to buttress. So immediately after the session, you will have the link to the recording and you'll be able to put up something else. Thank you so much, sir. That's that on this.
Thank you so much, madam. Thank you so much. So the next question.
Okay, sir. So, sir, we have a question from Oyin Consola. Thank you very much, sir, for this session. From Oyin Consola, can there be an overlap between IP rights when a person protects his work under various forms of IP? May I ask if I pronounce that name properly, sir?
I didn't get the question, please.
A question from permit me. Can there be an overlap between IP rights when a person protects his work under various forms of IP?
Yes, it's possible. Oh, it is possible. And I love the question. Because sometimes what a person does may involve an infringement of several rights, and it can also be, it may also constitute several crimes of IPR infringement. Take, for instance, somebody, what is the best fan that we have, or air conditioner, LG air conditioner. Some Nigerians do go to China and they will order air conditioners to be made and that LG's trademark be put on it. Now, when this product is brought to Nigeria, they will also print the manual in order to make it look like the original LG product, and they will package everything together. Pictures that LG printed, they will print the same pictures and put them in the package, and they will be brought to Nigeria. By putting LG trademark on a product that was not made by LG, that is a trademark infringement. By printing pictures in the manual, that is copyright infringement. By printing the manual, the word for word, that is copyright infringement of literary works, but those ones constitute literary works. So there you are already seeing what we call overlap. But the fact is that the conduct, the facts of the matter, the acts that were taken by the steps taken by the importer constitute infringement of more than one IPR. And so the U.S. Federal Bureau of Investigation, I've had the privilege of being a trainee under the FBI IP unit before. They will say that if you go out to conduct a raid, always ensure that you have the whole spectrum of IPR in mind, because even though you are working for the Copyright Commission, you may get there and you see that what they have done is what the police can take to court. Because if you don't find those manuals, if it is just the trademark that was infringed, the Copyright Commission will not be able to take a criminal action on that, but the Nigerian police can take action on it. And the same thing with medicine. Somebody has a formula for a particular medicine, and another person now goes ahead to reproduce the same product, does the package, does the what do they call it? The paper that is always inside the package that will show you the dosage. The paper that is printed constitutes copyright infringement, while the medicine that was reproduced constitutes an infringement of the patent that was given to the maker of the medicine. And then putting the name of the logo of the company, the name of the company on the package is a trademark infringement. So there can be an overlap. I hope you understood my explanation.
Yes, sir. I'm very sure that answered the question, sir. So moving on to the next couple of questions. Obeta Angela asks, there was this recent controversial issue between a fashion designer and a customer, where the latter accused the fashion designer of making a dress for another customer with the same design that had been used for a custom-made dress 2 years ago. In defense, the fashion designer claimed that the design was an intellectual property of that brand. Sir, please, what is your take on this?
Okay, thank you very much. You are quickening my desire to write a paper on IPR and fashion design. People get it wrong when on the intellectual property rights behind fashion in the world. There is no IPR that protects the design that you have made. None. What fashion companies are living on is their brand, which is the trademark. It is not the design itself. What makes some people to buy Chanel, Gucci, and the rest is the name. It is the name that whatever comes from Gucci must be quality and must be luxury. And people, when I wear it, and people see the Gucci sign or symbol, they know that I'm wearing something that is solid. Another fashion designer can pick up the same dress and make it the way Gucci has made it, but he must not affix Gucci sign on it. He must not. That is one. Now, the controversy you are talking about, I wasn't aware of it. But if someone makes a dress, let us assume, for the purpose of argument, that there is IPR in the dress he has made. The person he sells it to does not have a right, unless there's a written agreement between them, which is contractual. It's not IPR, to say you will not make this dress for someone, this type of dress for someone else again. If the person does that, then you can go to court to enforce your right under the contract. Or else, if indeed there's IPR in fashion, it is the maker of the dress that is the owner of the copyright, not the person he sells it to. Let me tell you this. Under the Copyright Act, as amended now, the question of commissioned works when it comes to artistic works and photographs was mentioned. A commissioned work that, look, Debussy, you are a first-class photographer. I want to take a photograph of myself. How much? 500,000 naira will take, or 50 naira take. When that person makes that work, the question is, who is the author of the work? The law has settled it that the author is the photographer. For crying out loud. If it is a painter, I'm saying a drawing artist, say, I want you to draw my portrait, and the person does that. Who is the author? It is the painter, not you. But the law has only tried to balance your right, your image right, what we call image right, with the copyright of the person who made the work, of the author, by saying that you have a non-exclusive right over that work to license the work. So it means that the photographer, even though he's the author, cannot sell your image without approaching you for consent. So if you take that one to the fashion, to the controversy that you mentioned, even though the fashion designer himself does not have any IPR over the fashion that he has done, someone else can do it. Someone else can redo what he has done. If in Nigeria, that there are some top fashion designers in Nigeria too. Taffy, what is it? Taffy? I think somebody in Ireland there. He charges a lot. Now, there are people who will always patronize him. I don't know whether it's him or her. Because when they wear his or her clothes, they have this satisfaction that it is Taffy's cloth I'm wearing, even if it costs them 10 million naira. If someone else sees that design and does it, and it's not Taffy, Such people will not even go to that person to patronize the person because they will not have the same satisfaction. So and that is where branding comes in. The logo, the symbol, the mark, which distinguish Taffy's clothes from the words of some other persons. I have done some research on this besides my knowledge of what IPR stands for, and I've not found any authority that says that there is copyright or a particular IPR in a design. The industrial design that we talk about is not the same thing as fashion design. Industrial design has to do with the image on a piece of cloth, not the making of a dress. Because when you have a piece of cloth, let me use Ankara, for instance. Your Ankara, the design that was made on the Ankara to make it look the way it looks is to be protected by means of industrial design. So when a cloth comes with dimensions, so it is not, it has nothing to do with the sewing of cloth. No, that is not industrial design. And I hope you all understood my explanation.
Yes, sir. Okay, sir. Please, sir, we still have, like, people are asking and are asking more questions. Would you be able to go over the 10 more questions we have?
Yes, please.
Okay. Okay, please, can we not add questions to the Q&A box? Any other question you have, please direct it to the evaluation form. So the next question that I have, Rukame Ofamaja, thank you very much for the session, sir. I live in Abuja, and there is a popular radio and media company. Its name is Brekete. The company recently had the name Brekete trademarked. Sir, my question is, should the company be allowed to trademark such a word that is a general Nigerian jargon, not allowing other people to use it, such as telecommunications companies like Global?
Okay. Thank you very much. You see, a person may desire to trademark a name or a mark or a symbol or a color or a shape. Even outside Nigeria, we are trying to do it in Nigeria without having to amend the law. It may trademark a smell or a sound. That may be your desire. But you must submit your application for registration to the Office of the Registrar of Trademarks, where this will be assessed. And there are professionals there who will now determine whether what you want to register, first, if it is acceptable, before we now talk of whether there's someone else who has been using that or who has registered that. So if at the end of the day, they accept to register it and they issue a certificate of registration, then you must believe that they have covered all the grounds. So it is not Berekete. They will not have just desire to use Berekete and to register to trademark Berekete, and then it's just using it without following the procedure. If it followed the procedure and at the end of it all, that word was approved for registration and was so registered, then there is absolutely nothing wrong with it.
Okay, sir. Thank you very much, sir, for that answer, sir. So the next question, please, sir, could you briefly explain again the distinction between copyright ownership when it comes to musical words? I could not properly hear your explanation, sir.
Reason what?
Come on, let me get back to the question. Could you briefly explain again the distinction of copyright ownership when it comes to musical works?
The distinction of copyright ownership.
Yeah, when it comes to musical works, sir.
The person must be talking about the distinction between ownership of copyright in musical works and ownership of copyright in sound recordings. And I mentioned that first, you must understand that there is a first ownership. First ownership. So it's a distinction between first ownership of musical copyright in musical works and first ownership of copyright in sound recordings. So we are talking about the authors. Who is the author of a musical work? The law says that is the creator of that work. So and we have said musical work, let's call it the lyrics, the composition. And the sound recordings is the composition, the lyrics, along with the accompanying sound, the percussion, the drums, the guitar, the keyboard, and the rest. They back up. That is what constitutes sound recording. That's why you can dance to sound recording. You can't dance to a musical work. And the law says that the first owner of a sound recording is the person who made the arrangement for the making of the sound recording, and that is the record company. Meanwhile, the first owner of a musical work is the creator, that is the person who created the musical work. The lyric, the composition is the composer, as the case may be. So that is the distinction between them.
Yes, sir. Thank you very much, sir. And sir, the last question we'll be taking for this session. If a person uses another person's work to advertise his own product, is it an infringement on the person's IPR? For instance, food made by another person, then you use it to advertise your own food since you make the same product. It would that be an infringement? Yeah, a very interesting question.
I don't think I need to answer the question because it is clear that you are using someone else's product, someone else's IP. But now the question is, what are you using in the person's food? Yeah, please get it right. Please get it right. When you say food, there is no IP in making food. But are you putting a logo to distinguish your food from the food of another person? That is where IPR comes in. If you make food, you are making butter, and there are so many butter manufacturers in the world. But you now start making your own butter. If you are making your own butter, and you not go to you pick ambassador butter, for instance, you remove the cover of ambassador from it. You put your own cover, with your own logo, and you are advertising it. Unless you tell somebody that what is inside this ambassador, nobody knows. What they are saying is the get-up. What they are saying is the logo, and it is yours. You are not infringing any right. Not at all. But if you want to make your own butter, but you are calling it ambassador, and you are using ambassador's cover to advertise your own, you are infringing on the ambassador's trademark. You are trying to pass off your own as if it was made by ambassador. It is not only trademark infringement that you are committing. You are also passing off the product, which is a common law tort. So I hope that answers the question.
Yes, sir. It does, sir.
Thank you very
Thank you
much.
so much, sir, for this session. Would have loved to stay and just hear all the things you have for us, but for the want of time, we're going to have to bring a close to this session. Thank you
Thank you so
so
much.
much for the insights that you've provided us, and I'm very, very sure that the future IPRO practitioners are here and have been inspired. Thank you so much, sir.
You're welcome. You're welcome. So bye-bye, everybody.
Thank you very much, sir. I am most grateful for your sacrifice and your support, your continued support for this platform. I do not take you for granted. Ladies, please help me send a resounding applause with your virtual hands
I can see
to
I'm
our
receiving them
great
already.
leader, our great learned senior here, who has always been a great inspiration in this IP space and in the legal space as a whole. I'm sure the fact has spoken for itself, right? So you don't need me to attach any evidence. You've heard from him. You've learned a lot, and this is different. I heard someone say, "Oh, I'm hearing things like the things I hear in the lecture," and I'm sure you know that this is even different from what you hear in your lecture hall, because this is mixed with practicality, with practical illustrations by virtue of his involvement in the practice. It's a different thing to teach and just go on, just a theoretical aspect. It's a different thing to teach from the practical experience that you have, and you cannot buy that anywhere. You can't buy it even in the book. So having the opportunity to hear from people like him gives me great joy, and it gives me great joy to introduce great mentors like this to every one of you, young ladies in the four walls of the university, or new wigs, or even established lawyers already on this platform. I urge you to make use of this great information that has been dished out to us without any payment, for free, just on the altar of sacrifice and service. So we are really grateful, sir. So every of the ladies here will connect with you. I will share his LinkedIn URL. He's on LinkedIn. Kindly go and connect with him. And please share your lessons and tag him. Please do that. You have learned a lot. If we were to pay for this, in fact, this will be an expert session that we will still be gathering the money for years to come. So this has been given to us for free. So we should please share it and tag him. So sir, please, this is from me and on behalf of the whole community of the Hilton Top Solicitors Female Virtual Internship and Mentorship Program, for which you have been a great part of the family already. We say thank you very much. We really appreciate you. Thank you, sir.
All right.
Yes, sir.
Bye-bye, everybody.
All right. Bye, sir.
Bye-bye.
Thank you.
Bye, sir. Thank you very much, sir.
You're welcome, my dear.
All right, Deborah, over to you. Thank you.
Yes, thank you very much, Ma, for this session. Thank you, everybody, for this session. So a brief rundown of the programs to come. So we're going to be having another session tomorrow. Remember, our presentation is tomorrow. We're going to have 2 sessions in the morning and the presentation at 4. Then on Saturday, we're going to have a morning session on CV and